There are some new details in the Bobo murder case. These three men are charged in connection with the 2011 kidnapping and eventual murder of that Tennessee nursing student. Her disappearance and the subsequent lengthy search attracted national attention. Authorities say they found her skull in the woods last September. The three suspects wait behind bars with no trial date set as yet. A key issue being the sheer amount of evidence in the case, more than 30,000 pages apparently, and 460 pieces of evidence collected in the past 4 years. Well, now there's a new plan centering around hiring one person to review and organize the evidence for all of the defense teams. That, advocates say, could speed up the process and clear the way for the judge to set a trial date. But will it work? Let's talk about it with our legal panel, criminal defense attorneys Troy Slayton and Whitney Boan. Welcome to both of you. This is the biggest case ever in the history of the Tennessee Bureau of Investigation. The amazing thing to me is that very little of this evidence that they have compiled has actually leaked out. They've been keeping a very close wrap on this case. But Whitney, what do you think about the idea of having one expert appointed who's going to sort of sift through the evidence and parcel it out to the three defense teams?
Well, as a criminal defense attorney, I'll be the first one to say that justice delayed is justice denied, especially when someone is being held in jail for over a year almost with regard to a case where there's very little evidence being put out there linking that person to the crime. However, this scheme to fast track the case and have one investigator or one person do the job of 3+ lawyers is problematic to me. There's no BOGO for justice. When we start talking about bargain basement justice, we start compromising someone's right to a fair trial. And I don't think it's appropriate when these individuals have conflicts of interest in terms of their varying interests as the three defendants to have one person do the job that their lawyers should be doing individually. That's when things fall through the cracks, and that's when we have problems.
Troy,
I have a big problem with it.
Do you see any problem with having the three defense teams have full access to all of the evidence and let each of them go at it the way they want to?
You know, as a defense attorney, you often want the case to get aged. And this could very well be a tactic of the defense team to object to something like this because they want the case to age. They want the evidence to get stale. They want people to forget or people to die even or witnesses to forget things for evidence to get stale. So as a defense attorney to object to that, that may very well be their tactic. But as far as a prosecutor, I would really want anything to have this case go forward more quickly.
The case, I mean, it began with her kidnapping back in April of 2011, so it's already more than 4.5 years old. But some of the accused have been in jail for quite some time as well. Is there the prospect that they can raise some kind of a speedy trial argument, Whitney, if they don't get this trial moving?
Well, they can, but what you also need to keep in mind is while this case is 4 years old and the prosecutors chose to make arrests as early as September of 2014, the prosecutors also chose to not release any information or evidence about this case until July of this year. So while there may be some incentive as far as nebulously speaking that defense attorneys would have some objective of delaying a case to, you know, make the case older and therefore better, they need to do their job and they need to do it right. It's better for everyone if this is only done one time, regardless of the outcome. The worst thing that could happen is that they get tried, they get convicted, and then this comes back and it's a whole other trial again because they didn't get a fair trial because their lawyers didn't have the time to do what they need to do. It needs to be done the right way. And I think that if that involves waiving their right to a speedy trial, then that's what it involves, and that's what happens sometimes to do the job well.
Troy, last week we told our viewers
John,
about
that's exactly.
Well, we told our viewers last
John,
week about.
I was just going to say that's exactly. That's
Sorry,
exactly what's happened here. These defendants have waived their right to a speedy trial. They could have had their trial much sooner, but their attorneys on their behalf have waived their right to be brought to trial quicker because they want it delayed. And they may also want to have the opportunity to fully explore everything. Look, this is a death penalty case, so they want to see everything.
It'll be fascinating to see whether this plants the seeds for some kind of an appeal down the road as well, assuming one or more of these guys gets convicted. It is Just an awful case. Thanks very much. Troy Slayton, Whitney Boan. We appreciate it. Thanks.